Welcome to the Tuesday, October 31st, 2023 regular meeting of the Board of County Commissioners. It's 1:30 p.m. We're in Harris Hall. Thank you for being here this afternoon. Good afternoon, Mr. Mokrajewski.
Good afternoon.
How are you doing?
Great.
We have a abbreviated agenda today. We had business this morning that many staff and commissioners took part in. So today on the agenda, I'll begin with any adjustments to today's agenda. Mr. Mokrajewski.
We don't have any from staff.
None from staff. Any adjustments to today's agenda? I see none. Then any emergency business? To the Commission, I see none. And so we'll move on to item 3A, Public Works, which is a continued public hearing. Now, I have a script before me, but we have a little bit of a deviation from what we had intended to do today. And Ms. Bell will give us a little bit more information surrounding that once we get to that point in the script. But the main staff person who was prepared to give the full report today is unable to attend. And so we're at the conclusion of this meeting, we will be moving the item forward to a date certain at the conclusion of this agenda item. So I'll go through the script. I have a script before me, and it's, if things have changed ever so slightly from this script, please do not hesitate to correct me, stop me, but I think I'm in pretty good shape as we move forward here. So, bearing in mind that we do have some changes to our original plan, I'm going to open the public hearing and briefly introduce a proposal. So I'll now open a public hearing on Planning Action File number 509PA20-05634. I am Pat Farr, Chair of the Lane County Board of Commissioners, and today's date is October 31st, 2023, and is 1:35 p.m. This is a quasi-judicial hearing on property owner-initiated Type 4 Application 2. 1, amend the Rural Comprehensive Plan to redesignate land from agricultural to residential. 2, rezone that land from E25 exclusive farm use to RR10 rural residential, and take a committed exception to a statewide planning goal 3. For quasi-judicial hearings, state law and county code require that I notify the applicant and participants of the procedures we will follow and of specific statutory notices. The order of the proceedings will begin with a staff report. Today will be an abbreviated staff report and presentation by LMD staff. Ms. Adams is not here. Ms. Bell will be providing that report. We will then hear from the applicant, followed by testimony from other interested individuals. Ms. Bell will then provide additional information in response to the testimony, and the applicant will have an opportunity to rebut any testimony provided. All individuals who provide testimony must state their name and address for the record. Now, at this point in time, I'm going to state that any additional testimony beyond the applicant will be limited to 3 minutes. After each presentation or testimony, the commissioners will have an opportunity to ask the applicant or anyone providing testimony questions before the commissioners, then move to close the evidentiary record. Before closing the record, commissioners should feel they have all they need to deliberate toward a decision. Deliberations are a time for the commissioners to discuss among themselves the evidence and testimony heard and determine if the applicable approval criteria have been satisfied. When deliberations have concluded or as part of the deliberations, commissioners may make a motion. Staff have provided motion options for the board's use in the supplemental agenda cover memo. The applicant bears the burden of showing that the proposal satisfies plan amendments and rezoning criteria cited in the agenda cover memo and attachments. Ms. Bell, could you please read the list of the applicable substantive criteria as listed in the ACM?
Yes, thank you, Chair. The applicable criteria as listed in the August 1st ACM is Oregon Revised Statute 197-732 2B for goal exceptions, OAR 660-428, OAR 660-418 2B related to exception area criteria, statewide planning goals 1 through 9 as applicable, Lane Code 16-400 8A 6H 8C, Lane Code 16-252, Lane Code 16-003 and 16-004, Lane Code 16-290, as well as Lane County Rural Comprehensive Policies, Goal 2, Policy 11, Goal 3, Policies 1, 3, 7, 8, and 12, Goal 5, Flora and Fauna Policies 7 and 12, Goal 5, Water Policies 1, 3, and 5, and related RCP Goal 6 policies and working paper provisions as referenced or relevant.
Thank you. Testimony, arguments, and evidence must be directed toward the criteria just listed or other criteria to which a person believes to apply to the decision. ORS 197.7975 provides that failure to raise an issue accompanied by statement or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal to LUBA based on that issue. ORS 197.7963 provides that failure of the applicant to raise constitutional or other issues relating to the proposed conditions of approval with sufficient specificity to allow the decision maker to respond to the issue precludes an action for damages in circuit court. Prior to conclusion of the public hearing and before the board closes the record, any participant may request an opportunity to present additional evidence, argument, or testimony regarding the proposal. The board must grant the request by either continuing the public hearing or leaving the record open for additional written evidence, arguments, or testimony. The board's decision will be the final local decision appealable to the Land Use Board of Appeals. At this point, I'm going to ask for disclosures. Commissioners must disclose any pre-hearing ex parte contact. If any commissioner has received ex parte contact, then please, for the record, one, disclose the substance, circumstance, and parties to such communication, and to state whether you can render a fair and impartial decision. Does any commissioner need to make ex parte disclosures? Commissioner Lovall.
Oh, no ex parte comment.
Commissioner Buck.
None.
Commissioner Senega.
None.
Vice Chair Trieger.
Thank you, Chair. In the abundance of caution, I'll just mention I did receive a packet of materials outside of the public meeting, but I immediately handed them off to County Counsel's office and did not read through the materials.
Thank you, Vice Chair Trieger. And for me, on March 20th, 2023, I received a message from Mr. Reeder, which I have checked, and it's outside of disclosure requirements. So I have no ex parte contact to disclose. Now I'll ask the commissioners to disclose any personal knowledge, bias, prejudgment, or personal interest or conflicts of interest. Commissioner Lovall.
None.
Commissioner Buck.
None.
Commissioner Senega.
None.
Vice Chair Trieger.
None.
And I have none. Does any commissioner need to disclose personal knowledge, bias, prejudgment, or personal interest / conflict of interest?
None.
Commissioner Lovall. Commissioner Buck.
None.
Commissioner Senega.
None.
Commissioner Vice Chair Trieger.
None.
And I have none. The applicant and all those in attendance are allowed at this point to rebut any of the disclosures heard, if any, and to challenge the qualification of any commissioner based on bias, prejudgment, or conflict of interest. Would anyone like to rebut what they've heard or challenge the qualifications of the commission? And Ms. Jones, anyone online?
I do have people online at this time. Would you like me to ask them to raise their hand if they have?
Asking for a rebuttal or a challenge to the qualification of the commissioners?
If you are online and you have heard Commissioner Chair Farr, please raise your hand if you have a rebuttal or a challenge of the commissioners. I do not see any hands being raised.
I see none. Thank you. Then, Ms. Bell, could you please introduce the documents before us and then provide staff report and presentation?
Thank you, Chair Farr. Good afternoon, Commissioners. I want to introduce this item. This is Planning Action File Number PA 205634. This is a proposal for a minor amendment to the Rural Comprehensive Plan to change the plan designation of the property from agricultural to residential, to rezone the land from exclusive farm use E25 to rural residential R10, as well as a proposal for an irrevocably committed exception to statewide planning goal 3. To provide you with a summary, the Planning Commission had recommended denial of this request. Their recommendation was based off of the proposal not meeting the requirements stipulated in the Oregon Administrative Rules for justifying an exception, They found that the record did not support the conclusion that adjacent development is likely to impede farm use according to the applicable legal standard. The record doesn't support the conclusion that farm use alone, or especially in conjunction with other properties, would be impracticable with standard farm management practices, and that the general sentiment was that the record does not indicate that serious attempts have been made to farm the property productively in the past or to analyze the practicability of farm uses now. As you may recall, this item came before you on August 1st. Additional material was provided. Staff supplemental cover memo for today's continued hearing includes an updated version of the preliminary draft order and findings in support of the Planning Commission's recommendation, which now accounts for the new testimony and information that's been provided since staff's original cover memo. That includes the supplemental findings and documentation submitted by the applicant on August 1st. The findings are preliminary, and they intend to facilitate board review. And I will note that the staff planner for this project is, as you mentioned, Chair Farr, was unable to attend today. Staff is the subject matter expert for this application. I will note that the plan amendment zone change applications are amongst the most complicated applications that we process. And of those, ones with goal exceptions are exceptionally complex. Staff work closely with these applications and have familiarity with the complexities, the intricacies of these proposals and the criteria. And so while I'll provide a abbreviated staff report and summary, it would be staff's recommendation to continue the hearing to a date and time certain. I believe that December 5th at 1:30 is available, is my understanding. And so I will provide a very brief summary of the remaining issues at a high level. And staff would recommend a continued hearing. I'll also note that the Planning Commission reviewed the file from August of 2022 through February 23. There's been several submittals over the course of the record that deserve careful weight. And there has been additional testimony since this last came before the board. There is a submittal from one of the neighbors that I believe has been forwarded to the board, as well as by a submittal from Landwatch, or two emails rather, from Landwatch and an email from Sean Malone. And then the applicant has hand-delivered a packet of material that has been distributed to the commissioners today. That's the testimony that I know of. Unfortunately, with the staff planner being out of the office, I'm not able to access materials that might have come in that simply I might not know about to distribute to the board. So that's another reason why we're recommending a continued hearing today. To give a summary of the staff evaluation of the supplemental material provided by the applicant, namely, staff have noted that with regards to exception criteria, the Oregon Administrative Rule criteria have not been fully met. And with regards to concerns raised regarding groundwater, the applicant has asserted that because the property is not in a significant groundwater area, that the Goal 5 standards do not apply. However, that's not the test as staff understands it to be. Goal 5 indicates, the working papers and the rural comprehensive plan indicate that groundwater, surface water are significant resources, and typically that is accompanied, an application is accompanied with an environmental, social, EC, environmental, social, economic, energy consequences analysis. And That has not been provided here. So that, as indicated by Lane County case law, requires an analysis of all the uses that are allowed by the current zoning compared with the uses allowed by the proposed zoning. That hasn't been done here, and that would evaluate if there's a conflict, and if there is a conflict, then you go through that full analysis. Even if there's not a conflict, then rural comprehensive plan policies for Goal 5, policies 3 and 5 apply and require analysis regarding groundwater. And that hasn't been done here. So I think I'll leave it there. Again, staff's recommendation is to continue the hearing to December 5th.
Thank you, Ms. Bell. Then I'll look to the board. Any questions or comments regarding Ms. Bell's presentation? I see none at this point, so we'll continue with the hearing. I'd like to invite the applicant or the applicant's representative to provide their testimony and evidence. Please be sure to state your name and mailing address for the record.
Good afternoon. Chair Farr, Commissioners, my name is Mike Reeder. I'm at 375 West 4th Avenue, Suite 205 in Eugene. I represent Chuck Perkins, the applicant for this application. So first of all, my best wishes to the staff member assigned to this application, Shauna Adams. I hope all goes well with her. I do want to begin a little bit with an acknowledgement that the Board of Commissioners often expresses appreciation to staff and also to volunteer members of the Planning Commission. And I want to share my appreciation for the Board of Commissioners for your work. So although this is, you could consider it your job, it's still public service and you have heavy lifting to do, especially when you have to evaluate much of the material or all of the material that's presented to you in applications such as this. I know you have many other things that are on your plate. So for that, I am extremely grateful for your service. Between 2013 and 2018, I taught land use law at the University of Oregon School of Law. And
Mr. Reeder, I'd have to interrupt for a second regarding timing of your testimony. We're allotting 10 minutes for your testimony.
okay, thank you. Okay, so I taught at the School of Law for 5 years, and during that time, the coursework that I assigned and reviewed on a semester-by-semester basis had to do with the police power, the ability of state and local government to regulate land use. I bring that up because there's 3 reasons why the board should approve this application. The first reason is that we have provided evidence in the record that shows by a preponderance of the evidence that the application meets the criteria for approval for a plan amendment zone change and a irrevocably committed exception. We provided that information to you back on August 1st in our proposed findings. Since then, there's been material received from opponents, material received from county staff, and material received by us that further analyze this issue. Nothing from staff and nothing from the opponents that we see casts into doubt or question our determination that the application meets the criteria. So with that, I recommend that the board approve the application as submitted, that the board direct the applicant to draft findings commensurate with that approval, and then provide it to you at your meeting where you would adopt it by ordinance. So that's reason number 1, and the applicant is happy to draft those findings. Reasons number 2 and 3 are provided in your written material, and I provided that to you in the draft findings of August 1st. The first is that as elected officials, you have entered into an oath to uphold the Constitution. So sometimes when we think of, when lawyers talk about the Constitution, often we're thinking about how LUBA or the Court of Appeals or the Supreme Court will determine whether or not an act is constitutional, whether a law is constitutional. your oath requires you to make that determination at the first instance. It is not up to you to determine, to have LUBA tell you whether or not it's constitutional or not, or the Court of Appeals or the Supreme Court. So with that, we have provided what I would call precautionary arguments or other additional reasons why this application should be approved. So if you think about it this way, there was a sign on I-5 that said pot land for sale. So that land that's zoned exclusive farm use along I-5 is allowed to grow a marijuana crop that is, under federal law, an illegal substance, yet it is illegal under state law and under the code for that property to receive a dwelling as of right. Okay, so you can grow pot, but you can't have a house and grow a family, okay? That is the structure of the system that we've inherited. Now, in 1926, the U.S. Supreme Court said that Euclidean zoning in certain circumstances is constitutional on its face. What it also said in 1926 was that, as applied, there are circumstances in which land use regulations that are otherwise constitutional cannot be applied. 2 years later, in the Nectow decision, the U.S. Supreme Court struck down a land use regulation that was valid on its face, but as applied in that particular circumstance was not able to be applied because it violated the 14th Amendment substantive due process provision, which says that public policy, you have to advance a legitimate health, safety, welfare, public policy. And when you cannot, when in an instance where a regulation would violate that, then the application of that regulation cannot be enforced. In addition to a 14th Amendment argument, we have made the argument that this property would not have value. There'd be no economically beneficial use to this property if a dwelling wasn't allowed on this 9.87 acre piece of property. This piece of property has stood alone as a discrete unit since 1947. If it's not allowed to have a dwelling on it, there is no beneficial use. Now, staff in the 23-page report that we received on Thursday suggests that, well, you might be able to do some wetland mitigation banking, or you might be able to have a religious use. Well, the response to that is the state law doesn't allow churches that would accommodate over 100 people in property that's within 3 miles of an urban growth boundary. This property is 1.5 miles from the Crestwell urban growth boundary. So that doesn't work. Economies of scale are necessary for wetlands mitigation banks, and 10 acres is simply not enough to make a wetlands mitigation bank work. So this property has remained fallow at least since the 1950s. The evidence in the record is overwhelming that this property has not been farmed, despite the assertions made by Landwatch and despite the very bare assertion made by Mr. Ballou, the neighbor. Has hay been cut? Yes, and the testimony suggests that hay was cut. It was terrible hay. There was no economic value in the hay, and it was done for fire suppression purposes. There's also evidence in the record that's actually in the hearings official decision on the legal lot verification that went before the hearings official that they tried to raise a cow and it didn't prevail. You know, the cow was going to starve on that piece of property. It's poor soil. We have gone through and we have looked at the responses to what we have provided in the evidence by staff in that single space 23-page proposed findings. There's nothing in there that has not already been addressed or been overcome. I've provided you evidence in the record today that shows that the developed and committed working paper addendum was adopted by the county and acknowledged by the state. So the tools that are used in that working paper that have been used in the Stauffer decision that's right next door in 2001, and also a decision called the Porter decision in 1999, both of those applicants used the Developed and Committed Lands working paper addendum. That addendum is what makes this application distinguishable from the case law that has been presented to you as somehow being in conflict with this application. In those cases where LUBA and the Court of Appeals have suggested that the mere presence of other dwellings nearby farm property is not sufficient to show conflicts between farming and the other property, those counties did not go through the effort that Lane County did by having 10 experts go through and provide an analysis for how many, when dwellings are adjacent to farming property of certain sizes, that property is no longer, it is irrevocably committed to uses other than farming. And I've provided you that evidence and that testimony in your packet today and previously. There's evidence in the record from Fred Stauffer, Ron Bowers, Bill Spencer, and Scott Carmichael, all who say that this property has never been farmed and would not be farmed. And others have suggested that they would never farm it. There's been questions about whether or not this is the right application. This is the right application for this property. The sky is not falling. Pandora's box is not being opened. This is a very discrete application and based on facts that are on the ground and in the vicinity that show that the application can be approved. There are very few of these properties in the county. I do not believe that this is going to set some type of precedent where there's going to be more and more dwellings in Lane County. In terms of groundwater, we've provided you testimony about groundwater. This subject property is not in a Goal 5 resource area. Yes, groundwater was of concern when Lane County had to go through the Goal 5 analysis back in the 1980s. What the county did was they went through the Goal 5 program. Goal 5 and the Goal 5 rule require that the county inventory significant Goal 5 resources, and they list the areas that are groundwater limited. This subject property is not in a groundwater limited area. The plan policies, the Rural Comprehensive Plan policies that have been advanced by staff as being applicable are not applicable because those policies relate to Goal 5. If you're not on an inventoried, if you don't have an inventoried resource on your property, you're not required to go through an ESSE analysis. You're not required to do anything. And in fact, this property cannot be further divided. The Lane County program is, under Goal 5, when you're in a groundwater limited area or when there's other triggers and you want to divide property, you have to go through the Lane Code Chapter 13 process of proving up on water. Not in a situation where you're doing a plan amendment zone change and you're not providing opportunity for further development, which could happen in, say, a large marginal lands application. That happened in the Seuss application a few years ago, where the Seuss applicants had to show that they could prove up on water under Goal 5. And in that particular case, the property, or at least a portion of the property, was in a groundwater limited area. This simply is not. And a de minimis domestic use for a dwelling for groundwater on a 9.87 acre piece of property should not, and it does not, but it also should not trigger a requirement to go through anything other than to show that your well works. And in this case, we have there's testimony in the record that the well produces 8.5 gallons per minute. I could go on, but I'll leave you with this. The Rural Comprehensive Plan policy, plan itself states in Policy 7, Goal 3, that agricultural lands in the county, some agricultural lands in the county are not suitable or available for agricultural use by nature of built upon committed, and that's us, committed, or needed for non-agricultural uses by using applicable comprehensive plan policies and the exception process of LCDC Goal 2, Part 2. The standard for an exception is demanding. We meet those standards. It's not an impossibility standard. The county has 3 reasons to approve this application, and we're happy to draft findings that will respond to everything raised by staff and the opponents. And I'm happy to answer any questions that you might have.
Thank you, Mr. Reeder. And I'll look around to the Board of Commissioners for questions at this point in time specifically for Mr. Reeder regarding this testimony. Commissioner Senega.
Hello, Mr. Reeder. I have a couple of questions, and it's in here, but for the record, how many neighbors, again, are touching this piece of property?
So I'm not sure. Do you have the PowerPoint presentation from last time? Okay, so, yeah, so let me answer it this way. To the north are small, I will say small because they're 1.87 acres each or smaller. And so there's the one that's 0.8 acres to the northwest, and then there are 5 other parcels, I believe, that are around, that are less than 2 acres. All are developed with dwellings except for one, which is, that can have a dwelling by right. And then there are the Stauffer dwellings to the east, which we've discussed before, that we can't count in the developed and committed working paper analysis. We don't believe we need to count them, but they're there. And then the property to the south is zoned EFU, and it has a dwelling on it. So the only property that doesn't have a dwelling to the west is the county road, and west of that is farm property.
Okay, thank you.
Any further questions? Commissioner Lovell.
Yeah, not really a question, but just more of a comment on the proceedings, Chair, if I may. I'm just kind of wondering in my mind that Mr. Reeder gets 10 minutes to present his case. How much time does the county get? Is it a balanced thing, or do we allow the county more time than the citizens get?
We typically have no timer on staff reports.
Just a question I brought up. This doesn't seem to me like there's a good balance of information that we gather from both sides.
Well, if I might, Chair Farr, I guess I know it's not a question, but if I could respond, I understand and I sympathize with that. What I would say is I represent many people in many counties, including Lane County. Not all potential clients who come to me or others like me have a factual situation like this where we say, yeah, let's go ahead and spend over $20,000 in 3 years to try and get something like this. They are very rare. So when I say that, because we can draft findings that are, that will go to LUBA that can be sustained. So whether I have 10 minutes, 30 minutes, I could bore you for hours. I mean, attorneys can talk all the time.
Those notebooks, and I assert that assumption that you made, for sure.
Thank you, Commissioner Lovell. And having given 10 minutes, it was my choice to choose 10 minutes. We could have gone 3 minutes, could have gone 12 minutes.
Chair Farr, I'm okay with 10 minutes. I'll take more if you want. I'm happy to answer any questions. This is very technical. Ms. Bell was correct. Exception applications are, other than urban growth boundary expansions, they're probably one of the most complex applications. Again, it doesn't mean that it's impossible to get them. It just means there's a lot of work that goes into them. And that work, I believe, has been done.
Thank you for understanding the time limit that I placed on that. We do have another substantial piece of information that you provided to us today, which we'll have time to look at. Which brings me to my question. This is regarding something you specifically said today. You know, this is a request for a change, a zone change. We do take that very, very seriously. And one thing that we should, and anyone should consider, is does this open the floodgates? Is this a case that would create a flood of other applicants with similar cases? And what you have said is a very discrete application. There are very few of these properties in Lane County, and it will not open Pandora's box. And I trust that you can substantiate that information.
Chair Farr and Commissioners, that is a statement of opinion based on my experience. In my experience, I have never, this is the only exception property application that I've ever been involved in. The only two that I'm aware of, there's probably more, but the only two that I'm aware of are the Stauffer decision, which was 2001, and then the Porter decision, which I provided to you. So that's, you know, I was in college when Porter, went through, so I'm not familiar with it. But I don't expect that you'll see a lot of these. But there's a reason why the Rural Comprehensive Plan acknowledges that this is a possibility, because think about it. Back in the 80s, when they were doing the planning and trying to determine what was exception property and what wasn't, they didn't have the tools that we have now, and frankly, they didn't have the time. So my commentary is they didn't get it right all the time. This is an opportunity, this is a way for us to get it right and make it properly planned and zoned.
Thank you for that last statement. They didn't get it right all the time back in the 80s, and this is an opportunity, in your estimation, to make an adjustment based upon what potentially was not made correct decisions 45 years ago. Okay, thank you. That's all the questions that I have. Any further questions? At this point, then, I'm going to open it up for other public testimony. We have no one signed up in Harris Hall for public testimony. So, Ms. Jones, I'll ask you, do we have anyone signed up online?
Thank you, Chair Farr. At this time, I do see a couple people out there. If you have registered to give public testimony on this item, please raise your virtual hand and I will call on you. I will also give you the option to be on camera if you would like. So if you would like to give testimony, please raise your virtual hand. There goes one. Okay, they're both. I will start with Lori Segal and then take Sean Malone. Lori, I'm going to unmute your microphone and ask if you'd like to be on camera. Would you like to be on camera?
No, thank you.
Okay, if you give me one moment, I need to just reset our timer to be a 3-minute timer. 1 minute.
I'd like to pass the floor to Sean Malone, please.
Okay, I will mute your microphone. Sean Malone, I will unmute your microphone and ask if you'd like to be on camera.
Sure.
Okay, 1 moment. You will see, you will be switched to a panelist and you will see an option to unmute your camera and your microphone again. Where are you? There you are. Mr. Malone, can you, we can see you, and I will start the timer in 1 moment, and we'll hear your testimony. Okay, you may begin your testimony.
Thank you. Sean Malone on behalf of Landwatch Lane County. We've submitted testimony today. We've submitted testimony twice in the past on this application. We incorporate all that prior testimony, as well as the staff reports, including the staff report submitted today. As I started out my testimony on the last time we were here, there's no need for the Board of Commissioners to listen to Landwatch Lane County as to this application, but rather to listen to staff, your Planning Commission, DLCD, and the Oregon Department of Agriculture. Staff has identified a variety of legal issues that have yet to be addressed. The Planning Commission based its recommendation of denial on many of those same legal issues. DLCD has weighed in, noting that the addendum to the working paper is not an applicable authority that can be used to aid in the approval of this application. Finally, Oregon Department of Agriculture has weighed in, noting that, and I believe some information from them was sent in today. They've weighed in again, saying that the soils on the subject property indicate that it can be farmed, that there are other farms in the surrounding area on the same type of soils that are engaged in farm uses. So again, it's not so much an issue of Landwatch, but a host of other entities that are recommending sort of denial here. Here we have a post-acknowledgement plan amendment, in addition to an exception and a zone change. For these post-acknowledgement plan amendments, there has to be consistency with the comprehensive plan. The comprehensive plan has a water resources policy, number 3, that requires a showing of an adequate water supply, and that's for applications that are major land use changes. A major land use change is an application that's reviewed by the hearings official of the Planning Commission. So that policy has to be complied with, not because it's on a designated list of groundwater quantity limited areas, but rather because it's a major land use change that applies as a result of the process we're in and the language of the comprehensive plan. Real quick, the constitutional issues identified by the applicant, including this Lucas v. South Carolina Coastal Commission case, is sort of the facts of those two cases, of that case, is very dissimilar than this, so you can't really go on that constitutional issue. My time is up already, so with that, I will just ask that the commission grant the continuance requested by staff and in the alternative to deny the application. Thank you.
Thank you, Mr. Malone. I do still see Lori Siegel with your hand raised. Lori, would you like to give public comment? Looks like Lori put her hand down. So with that, we are done with public comment online, and I'll return the meeting to you.
Thank you, Ms. Jones, and I'll take a moment to look around Harris Hall to see if there is anyone else in Harris Hall wishing to provide testimony to the Board of County Commissioners. I see none. Then we'll move along. Staff, do you have any additional comments or information in response to the testimony that we just heard?
And at this time, again, we do request a continuance of the hearing, or in the alternative, staff has recommended denial of the application based off of the supplemental staff report that's before you. We would anticipate providing response if the hearing is continued.
Thank you, Ms. Bell. Then I'll look to the Board of Commissioners for questions or comments. Vice Chair Trieger.
Chair, I'm just prepared with a motion.
Very good.
If you're ready for that.
Then we have nothing provided by staff, so the item labeled applicant's rebuttal, I guess, is moot at this point in time. There's a spot on my script here for an applicant's rebuttal. So shall I go forward with that?
I think that we could allow Mr. Reeder an opportunity to respond to public comment that was just received to kind of tie a bow on this abbreviated public hearing.
Thank you, Ms. Dorman. And then also subsequent to the final discussions that we have, the applicant will have an opportunity to comment at that point in time. So at this point, Mr. Reeder, I'll ask you to step to the mic and we'll give you 3 minutes for rebuttal.
Thank you. I'll try not to need 3 minutes. I'll try and put the bow on quickly. Just responding, again, for the record, Mike Reeder for the applicant. Responding to Mr. Malone in regards to the comment that the addendum, the working paper addendum from 1989 is not applicable authority. That's wrong. This is an adopted by the Board of Commissioners, acknowledged by the State Land Conservation Development Commission. It is part of your comprehensive plan, and I provided you the ordinance from 1989 in today's packet that shows that to be the case. So that's clearly an error. Regarding the soils, I've also provided you testimony in the record about the soils and about the applicability of that. For a developed and committed or an irrevocably committed application, whether the soils are high value or not high value is not relevant. It's relevant in non-resource applications, but not in this particular case from a legal standpoint. However, the fact of the matter is that the property can have high value soils if it's properly drained. To be properly drained, you need to have significant investment in draining. In the Porter decision, there was testimony adopted by the commission back in 1989 that cost would be exorbitant in that particular case, and the facts in that case are very similar to ours. So to the extent that it's even relevant, those inputs would make the property impracticable to be farmed. So unless there are any other questions, that concludes my rebuttal comments.
Thank you, Mr. Reeder.
Thank you.
Then we'll look for a motion. Vice Chair Trieger.
Thank you, Chair. I move to continue the public hearing to December 5th, 2023, 1:30 p.m. time certain here in Harris Hall.
Second.
Moved by Vice Chair Trieger, and seconded by Commissioner Buck, a continuance to December 5th. Did you say a time?
1:30 p.m.
1:30 p.m. Discussion to the motion? I see no discussion. I'll call for the vote. All those in favor, please say aye.
Aye.
Passes unanimously. Thank you for your presentation, Mr. Reeder, and to the Perkins, thank you for being here today, and we will look for more information prior to and on December 5th. Thank you. Very good. Then we'll move down our agenda today, and we'll move on to item number 4, which is our standard public comments section. Do we have anyone signed up for public comment in Harris Hall? Ms. Jones, do we have anyone signed up for public comment online?
One moment, we do still have one person online. If you would like to give public comment, please raise your virtual hand and I will call on you to give public comment at this time. No hands are being raised, so I will return the meeting to you, Chair Farr.
Thank you, Ms. Jones. And I'll ask once again in Harris Hall, anyone in Harris Hall wish to provide testimony to the Board of County Commissioners? I see none. I will close the public comment and look to the commissioners for a response to public comments and/or other issues or remonstrances. I'm looking around. Commissioner Buck.
Thank you, Chair. I just wanted to share that we've been having the Oregon Wildfire Recovery Summit yesterday and today, and it's been going really well. It's been packed. We've had a number of really excellent speakers. We've had our senators speak. I think there was a video of the governor speaking as well. Representative Al Hoyle was there this morning to speak in public, and Representative Marsh and Representative Conrad were on a panel, along with a multitude of other experts. I think it's been a great success, and we hope to see the fruits of that labor and all that gelling of minds across the state. People came from across the state to attend. I'm just excited to see what comes of it, and hopefully in the future there will be a way in which we can continue the effort, hopefully on an annual basis, but we'll see where it goes. Thank you, Chair.
Thank you, Commissioner Buck. Further remonstrances or other issues? I see none. I'll just state that I beg your pardon, Vice Chair Trigger.
That's fine. Thank you, Chair. I just wanted to comment as we're heading into cold weather season and holidays when folks gather indoors. I was fortunate enough to be able to get an appointment with my primary care provider to get flu and shingles and a COVID boost shot all within the last 2 weeks. And just want to encourage the general public to please consider doing the same to keep yourselves and our entire community safe and healthy. Thank you, Chair.
Thank you, Vice Chair. And I'll just state that I was at the Wildfire Summit yesterday briefly, and remarkably well attended, Ms. Morgan-Isley. We had people from all throughout the state, and I believe that Mr. Steve Adams had something to do with the organization and bringing that forward to us in conjunction with the University of Oregon. Really well done. I'll pass that along. It was remarkable, the presence and the contributions that took place. Very good. Then we'll move down the agenda to our consent calendar, which is item 6. We have before us a consent calendar. All of the items on the consent calendar will be considered with a single motion. If any item on the consent calendar needed separate discussion, it would have been pulled from the consent calendar for a separate discussion. Any items on the consent calendar, if you click on View Material on the Board of County Commissioners agenda for today, you'll see all of the material that the Board of County Commissioners considered prior to leaving this on the consent calendar. And with that, we'll pass this in a single motion. Vice Chair Trigger.
Thank you, Chair. I move approval of the consent calendar as published for Tuesday, October 31st, 2023.
Second.
Moved by Vice Chair Trigger and seconded by Commissioner Laval. The October 31st, 2023 consent calendar. Discussion to the motion? I'm seeing none. All those in favor, please say aye.
Aye.
Passes unanimously. So we'll now move down to item 7A, which is human resources. And Mr. Mokryski, we're going to have a discussion in the matter of adjusting the base annual salaries of Lane County's elected officials. And we have a panel with us today. And Mr. Mokryski, I'll allow you to introduce or allow the panel to self-introduce.
Thank you, Chair. I think, and Janice, are you going to take this item? We have Janice Reynolds, the Chair of the Elected Officials Compensation Board.
Yes.
You want to take lead? Okay.
Sure. I have some notes here, and you guys have your packets, and so I wanted to just read over my notes while you guys go along in your packets and follow. Okay. Good afternoon, Commissioners. I am Janice Reynolds, the Chair of the Lane County Elected Officials Board Compensation Board. With me today are Eliza Kaczynski, and she's a Senior Classification and Compensation Analyst for Lane County, and Alana Holmes, the Director of Human Resources for Lane County. The Elected Officials Compensation Board, or EOCB, is a 5-member citizen board charged under state law with reviewing compensation for elected officials on a year basis and providing recommendation to the Board of Commissioners regarding potential adjustments to compensation amounts for elected officials. The Board of Commissioners is responsible under state law for setting the level of compensation for the elected officials of the county. The EOCB met in the spring of 2023 to review elected officials' compensation and produce a recommendation. The methodology used for the review was similar to that used when determining compensation adjustments for all other employees at the county, and included looking at the compensation provided by 5 other counties in Oregon of a similar size to Lane County, and reviewing total compensation, including benefit packages. The review found that the sheriff and the justice of the peace compensation were closely aligned with the average compensation provided by our comparators. The assessor and district attorney's compensation was a little bit below the average compensation provided by our comparators. And the Board of Commissioners' compensation was significantly below the compensation of Board of Commissioners in other counties. The EOCB presented its recommendations to the Lane County Budget Committee on September 28th, and the Budget Committee voted to forward on the recommendation to the Board of Commissioners. Draft minutes from the meeting are included in your packet. For all elected officials, the EOCB recommended a 2% cost of living adjustment. This is consistent with the cost of living adjustments that have been provided to other Lane County staff in recent years. In addition, the EOCB recommends a 1.78% market adjustment for the district attorney, a 5.81% market adjustment for the assessor, and a 27.22% market adjustment for the commissioners. These market adjustments would align the compensation for these positions with the average compensation of other counties. On a final note, the Lane Charter regulates the timing of compensation adjustments for the commissioners. We are recommending that the adjustments for the assessor, the district attorney, justice of the peace, and sheriff be effective retroactive to July 1, 2023, which would roughly be a year and a half after their previous adjustment. Under the Lane Charter, adjustments to commissioners' compensation can only become effective after the next general election. So the EOCB recommends that the adjustments for the commissioners become effective in January 2025, which would be after the November 2024 general election. So the EOCB today is asking that the board to approve the compensation adjustments for the elected officials as recommended by the EOCB and the Budget Committee. Thank you. And I'm happy to answer any questions.
Thank you. Then I'll look to you, Ms. Holmes. Anything you'd like to add before we go to questions from the board?
Chair, Vice Chair, at this time, I don't have anything to add. I think we look forward to any discussion and questions that you have. And we have Eliza with us as well, who can dive into any of the specific details if needed. Thank you.
Excellent. And there may be questions under each order as we get to it. We have 5 orders to consider today, but prior to taking any motions for any orders, are there any questions or comments? Vice Chair Trieger.
Thank you, Chair. Thank you, Ms. Reynolds and panel. I have one question, just as much for the record as anything else, and it's probably to Human Resources Director Holmes. The base wages have increased for each of these positions at one time or another throughout the last several years. And of course, here at Lane County, we place a high value on ensuring compensation for all our employees, represented and not, is within a certain range of market, plus or minus. So can you let us know, or remind those of us who do know, the last time the base wage was increased, of course, particularly for the commissioners, since that's the most significant increase we're looking at, why that gulf is so large, and as distinct from the last time or the number of times commissioners have seen a COLA?
Chair Farr, Vice Chair Trieger, those are really good questions. And I have been assured that Eliza has the specific data with respect to base salary, and I believe significant COLA information depending on how much you would like. So if it's all right with you, I'll turn to Eliza for that response.
Thank you, Commissioner Trieger and Chair Farr and Commissioners. The last time the Board of Commissioners received a market adjustment was in 2016. That was a $10,000 adjustment. Before that, I haven't been able to find a market adjustment looking back to 1994. So if between 1994 and now, there's been one market adjustment. The COLAs, the last time the Board of Commissioners received a COLA, they passed COLAs for the 2018 and 2019 years, so there were 2 years with COLAs there. Those were 2% COLAs. Those were consistent with the COLAs that were being provided to other employees of the county at that time. The Commissioners has, in general, looking back through time, provided COLAs roughly half to 2/3 as for themselves, as often as they provided COLAs for other employees in the county. So that's one of the pieces, is that they're less likely to get COLAs than other employees of the county, which is leading to sort of that larger gap. And as far as how that connects to the market analysis, we do market analysis fairly regularly for all the other employees of the county. We typically do it either in conjunction with bargaining or for non-reps, trying to do it roughly on the same schedule. So other classifications receive market adjustments as needed, usually on a 3-year kind of cycle.
Thank you. Follow up, if I could. So that market adjustment of $10,000 to the base wage about 8 years ago now, do you know where that put commissioner wages relative to our comparator counties? Did it bring us into market, plus or minus 5%, still out?
I don't have that information with me right now.
Thank you.
Thank you, Vice Chair Trigger. Further comments or questions? Okay, then we have before us a series of orders, and the first one is Order 23-10-3104 in the matter of adjusting the base annual salaries of Lane County's elected assessor. Vice Chair Trigger.
Chair, I move approval of Order 23-10-31-04 in the matter of adjusting the base annual salaries of Lane County's elected assessor.
I'll second.
Moved by Vice Chair Trigger and seconded by Commissioner Buck. Discussion to the motion. And just for the record, I'm looking at the order itself, and that is a matter of $10,593 for a new base salary of $144,233. I see no further discussion. All those in favor, please say aye.
Aye.
Aye. Any opposed? Passes unanimously. And then we'll move next to, get my right number here, Order 23-10-3105 in the matter of adjusting the base annual salary of Lane County's elected district attorney. Vice Chair Trigger.
Chair, I move approval of Order 23-10-31-05 in the matter of adjusting the base annual salaries of Lane County's elected district attorney.
Second that.
Moved by Vice Chair Trigger and seconded by Commissioner Lovell. Discussion to the motion. Now, a little bit of a clarification on this motion. The motion makes it look like we're not paying that district attorney very much money at all. Comparatively speaking, the amount we're looking at is $2,345 in adjustment to a new base salary of $63,861. Does anyone care to comment on why that is just $63,000 for a district attorney?
The district attorney receives the bulk of her compensation from the state directly. So when we compare the market for a district attorney, we're looking at the county's contribution. All of the counties receive the same contribution from the state for their district attorneys, and most of them provide additional compensation on top of that.
So this adjustment brings us roughly in line with the other competitor counties?
Yes.
Very good. Any further questions? I see none, then I'll call for the vote. All those in favor, please say aye.
Aye.
Aye. Any opposed? Passes unanimously. Then we'll move along to the next motion, which is, next order, which is 23-10-3106 in the matter of adjusting the base annual salary of Lane County's elected Justice of the Peace. Vice Chair Trigger.
Chair, I move approval of Order 23-110-31-06 in the matter of adjusting the base annual salaries of Lane County's elected Justice of the Peace.
I'll second.
Moved by Vice Chair Trigger and seconded by Commissioner Buck. Order 23-10-3106, discussion to the motion. I will make a note then that according to the order, that is an adjustment of $1,157 for a new base salary of $59,016, which is a part-time position.
Yes, Chair Farrar, it is a halftime
A
position.
half-time position. Thank you very much. Further discussion? I'm seeing none. I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed? Passes unanimously. And we'll move along to the fourth order, which is Order 2310-3107 in the matter of adjusting the base annual salary of Lane County's elected sheriff. Vice Chair Trieger.
Chair, I move approval of Order 23-110-31-07 in the matter of adjusting the base annual salaries of Lane County's elected sheriff.
I'll second that.
Moved by Vice Chair Trieger and seconded by Commissioner Lovall. We have Order 2310-3107. Discussion to the motion. I'll make note that according to the order, that is an adjustment of $3,417 annually for a new base salary of $174,282. Further discussion? I'm seeing none. I'll call for the vote. All those in favor, please say aye.
Aye.
Any opposed? Passes unanimously. Okay, that's it. Oh, wait. Then we'll move along to Order 2310-3108 in the matter of adjusting the base annual salaries of Lane County's elected county commissioners. Vice Chair Trieger.
Chair, I move approval of Order 23-110-31-08 in the matter of adjusting the base annual salaries of Lane County's elected county commissioners.
Second.
Moved by Vice Chair Trieger and seconded by Commissioner Buck. We have Order 2310-3108. Discussion to the motion. Commissioner Seneca.
I'll just say this is a very awkward position to be in, to have to vote a pay raise for you. I understand almost the predicament the county is in at this point with us getting further and further behind. But as what I'm going to call a new commissioner still at 11 months in, I'm not comfortable with a pay raise.
Thank you, Commissioner. Further discussion? Excuse me, Commissioner Buck.
Thank you, Chair. You're right, this is always awkward every time it comes up. And there have been times in which I voted no for pay adjustments. And there have been times where I've been in favor. In the past, when I was just starting out as commissioner as well, and then we hit COVID times and we hit wildfire times. We had this come in front of us. I was not in favor of any adjustments. For me, it didn't make sense when so many of our fellow residents were hurting. Some were out of jobs. The future was unpredictable at the time. And, you know, timing has a lot to do with when it's appropriate and when it's not appropriate to make adjustments in compensation, especially when you have to do it for yourselves. And you're using taxpayer dollars and you want to be transparent and you want to know, you want to let people know how hard you're working for them. And that the work you do is significant and is making a difference. I feel at this point, this is the appropriate time in which to make a statement that says we are going to treat ourselves the same way that we would treat any other employee, any other staff member. We do market rate adjustments for them almost, it seems, on a constant basis, including COLAs and readjusting contracts on a very regular basis. We're doing some hard work up here, and I want people to know that I'm representing them 100% of the time, all of the time. It is very humbling to be up here as a representative of the residents of Lane County, and I do work as hard as I possibly can on their behalf. I hope that they can see that and note that market adjustments are and should be done on a regular basis for not only our staff, but as leaders in our community, we need to walk our talk as well. And for that reason, I'm in favor. Thank you, Chair.
Thank you, Commissioner Buck. Further discussion? Commissioner Lovell.
I guess if we're making statements, I should probably get in line. Yeah, this is obviously a tough time to do this. It's one of those things where, frankly, you couldn't pay me enough to do this job. This job's very demanding. You have a target on your back. People say bad things about you. You get bad emails. You get very little compliments to your hard work. And I know Commissioner Buck and Chair Farr and Commissioner Senega and Commissioner Vice Chair Trigger work our brains off for our constituents, and we think and sleep day and night about it. But at the same time, going into this run, I didn't even know this was a paid position until 2 months into the campaign. And in my campaign, I said that I would not support any pay raises. And so for that premise alone, I'll keep my word and not support this matter. Thank you, Chair.
Thank you, Commissioner Lovell. Vice Chair Trigger.
Thank you, Chair. I can see the position of all of my colleagues who've spoken before us, but I particularly do want to say that we're here to represent not only our constituents, but the health of an organization. And this is just a compounding, self-perpetuating problem if we don't take the leadership step to help close the gap, as well as consider, since we have a charter review committee, working with them or in future years to potentially looking at another way of managing this growing income inequality that we are perpetuating at Lane County. It happens to be for a particular position, in this case, county commissioners, and that is by virtue of how our charter is structured. And that charter is very out of date, as is the base wage for these 5 full-time positions. Even were we to approve this order, we are still by no means necessarily the highest paid workers in this county, but I believe that's appropriate because the work of us as a board is shared across 5 as opposed to one person being in the role. But I do still believe in equitable wages, and I think that it's an important step that we take, as I said, to help sort of right the ship and get us onto better footing so that we can then do the next heavy lift of figuring out structurally how we can avoid putting future boards in this position of having the better part of a decade before somebody's willing to take the difficult vote and do the right thing. So I am in support of the motion, and I want to very much appreciate not only the Elected Officials Compensation Board, who works as volunteers and who are HR professionals in our community and are very thoughtfully considered to take on that work and put a lot of effort in, but also our Budget Committee, who then heard the presentation from that board. So this has been vetted and through several steps and processes. I want the public to know this is not something that commissioners are just sort of it's not a power grab on the part of commissioners. And I think we're taking a very responsible and important step if we are to approve this order. Thank you, Chair.
Thank you, Vice Chair Trigger. Then just a couple of things. I'm going to go back to history. Back in 1995, I became a Eugene City Councilor, knowing that it didn't pay, and under the understanding that it took about 18 hours a week. Well, I think, Ms. Holmes, you work with the Eugene City Council, and you know that it's not 18 hours a week. I was working 35, 40 hours a week plus, full-time plus job at a growing company in West Eugene. 6 years into my job as a city councilor, there was a movement to give the city council a $1,000 stipend. I didn't support it. I voted against it. We ended up putting it on the ballot, and the public agreed to a $1,000 stipend for the city council 6 years into my work, and $2,000 for the mayor. I think it's been adjusted a little bit since then, but it's still stipended for the work done. In 2016, we did approve a $10,000 increase in pay for county commissioners, significantly less than the compensation board recommended at the time. But it was more or less a compromise that took place with the county commission at that point in time, knowing that the lift wasn't high enough to bring it up to what is comparable. And Ms. Mokryski, you remember when we had a similar situation where our non-represented employees had not received compensation adjustments for years. And when we made that adjustment, it felt like there was a lot of sticker shock involved with some of the Board of Commissioners at the time, but we did make that adjustment. And since then, the adjustments have been minor, just really adjustments, tiny adjustments, just to keep up with the cost of living, basically. This is a step in that direction with the Board of County Commissioners. I'll be calling for the vote in just a moment, but first I'll state, as I have with the other orders, that this is an increase of $26,157 a year for a new base salary of $114,026. You can compare that to the other numbers that I'd read off in the previous 4 orders. But that being said, there is one difference in this, and that is the effective date, which is January 1st, 2025. Kind of just coincidentally, maybe the day after my term ends. Just, it's just a matter of time that that's the way the charter is written. So with that, I'll ask for any further discussion. I see no further discussion at this time. Then on order 23-10-3108, I will call for the vote. All those in favor, please say aye.
Aye.
Aye. Opposed?
Nay.
Passes 3-2 with Commissioners Lovall and Senega opposed. Thank you, Board, for that discussion and deliberation. Thank you, Ms. Holmes, and thank you for being here, and thank you for the work that brought you to this point. Excellent.
Thank you all.
Then we'll move down to item 8A on under County Administration. Mr. Mokryski, we have we're looking to take action on a letter to the Bureau of Emergency Management in response to an open comment period on the draft wind energy area, option A of the Coos Bay call area. And Ms. Mokryski, I'll ask you to introduce Judy Williams, who we all know quite well. And my understanding, Ms. Williams, is that you'll probably go into more detail, but there is a deadline on this letter to submit comment, and that deadline, I believe, just happens to be today. So, Mr. Mokryski?
Yes, Judy Williams, Chief of Staff and County Administration, is here to walk you through this item that was added late in the agenda process because of the deadline that is today. So you pulling up a couple slides, Judy? I think we wanted to share with the board some context. You've had public comment the last few weeks on this issue. We've received a lot of questions and concerns from residents, particularly on the coast in West Lane County, and so we want to provide some of those facts to you and seek the board's, let you know about the deadline, and then seek the board's guidance on how to move forward.
Thank you, Steve. Good afternoon, Chair and Commissioners. Judy Williams, Chief of Staff. I have just a few slides that I prepared just because I think this is coming to you as of yesterday. Two, I think it's a complicated issue that may just not come to mind. And so for me, I'm a visual learner too, so I put a few slides together. I won't take up too much time, but just wanted to see if that could help prepare. So briefly today, just going to walk through kind of the why are we here. There is a deadline of today for public comment. There is a notice from the Bureau of Ocean Energy Management inviting that public comment, and that is due at 11:59 or midnight tonight. I'm going to try and review a little bit of the process and next steps, and then there is an attached letter, a draft, and open to discussion at the end if that draft letter is okay as written, and if there's a desire to send that forward. A little bit, too, about the process. While it is in front of you and came to you yesterday, I was made aware of the deadline Friday, that there is this opportunity. And while there has been a little bit of public comment around the topic, I didn't know myself how much, I heard Coos Bay and I heard wind energy, and I just didn't think that there was a lot of application for the county. But when I did look to see what that deadline to confirm, that is in fact the deadline, and that there is some areas just off the shore of Lane County. So I looked into it, and I know that it's late coming to you, but I think if we had a little bit more time, there could have been a typical board assignment and a presentation perhaps. So with that, I'm trying to give a little bit of a presentation. So in general, with the Biden-Harris administration, there's really a goal in terms of energy production around 30 gigawatts for floating offshore wind. The Bureau of Ocean Energy Management, also known as BOEM, is leading that effort, and there are sites all around the nation, Hawaii, California, the Gulf, and the Atlantic Ocean as well, that are all being looked at and moving at different paces. Really in 2020 is where some of this kicked off. So there was a task force initiated. Oregon became more involved in terms of BOEM, the federal agency working with Oregon Department of Land Conservation and Development, DLCD. And together, at the federal and state level, really came up with what does a plan look like in terms of engaging residents. In 2021 is really when some of the work came to place to identify locations. And so on the map, there is a border just off the coast of Oregon, about several miles off the coast, all the way from the northern border of Oregon to the southern Oregon. So you see like a line outlining what's called a planning area. So this planning area is where things started in terms of looking at both the depth, so looking at the depths less than 1,300 meters, and looking at an average wind speed of less, or at least 7 meters per second, to see where could we even look at for opportunities. Once you get outside of that planning area out towards the ocean a little bit more, there's a significant drop off, and that does not become as suitable. So I'm just trying to show you how this came about. In 2021, there was just a lot of conversations around outreach, getting information, what might be suitable. After a lot of conversations and some outreach, and I think you'll hear a theme here, and I'll try and touch on the outreach. There were 3 identified call areas, is what they're calling these bigger areas. So you see 3 on the map. There's only 2 now, as the one just off the coast of Bandon has been removed from consideration due to issues with commercial fishing and conflicts there. So there's 2 call centers, or call areas, excuse me. Once those big kind of swaths became identified, there was a lot of data gathered. This was largely in 2022. I know that the Port of Siuslaw gave a lot of comments and provided a lot of feedback at this point as well. So really through a lot of data and further analysis, ocean planning modeling, suitability, scoring, geospatial data, looking at setback distances, and looking at constraints. And in that top one that you see a lot of red there, that is the Coos Bay call area, and the red is really the constraints. So knowing that won't be a good location for offshore energy, mostly due to the Department of Defense needs in that area. So with all of this data, all of the input, essentially layering about 400 different layers of detail about types of fish in what areas, commercial fishing information. There was some good outreach to the Pacific Fishery Management Council, and although they have quite a few concerns still, there was some documented outreach that helped identify some of this area. So once they look at what are the constraints, we're really narrowing down that to 2 areas. So A and B are those just the 2 call areas. One is called Coos Bay Call Area. That's the one that is offshore of Lane County. And in the south, the Brookings Call Area. So in the blue, these are really just the only areas that would be moving forward for a lease option, auction, moving forward to development of energy production. So it wouldn't be outside of that blue area. But as you can see, Florence is at the north end of the Coos Bay Call Area. So, Dune City just south of that. And so some areas, it's around 35 miles off the coast of Lane County, that at the tip of A in the map. But there's just a lot of unknowns in terms of next steps around what things might look like. I think there's just a lot of options, a lot of questions, concerns, and wanting some visualizations in terms of what, is it 1,000 feet in the air, what these windmills might look like. But does seem like they will be visible from many key points offshore of the coast and with lighting. And so one of the concerns, or some of the main concerns from our coastal communities and the Confederated Tribes of Coos, Lower Umpqua, and Siuslaw Indians are really around that visualization and a desire to have more conversation and data mapping so that we could better tell what things might look like. So briefly, just to kind of give you an idea of what I found in some of the research around issues, a lot of concerns around outreach. So in reaching out to several of our coastal communities, organizations, there's a lot of positives around wanting, energy production, wanting to be a part of it, but also just feeling unheard or having a lot of questions. There was a letter from the governor, Senators Wyden as well, and asking for a pause. So the Bureau of Ocean Energy Management does not need to give opportunity for comment on these areas, but they, after some feedback with the governor's office, did issue this 60-day public comment period. And so this is what we're up against, this 60-day. So good news in that there's a little bit more opportunity for that public comment, but still some concerns definitely voiced from the tribal governments and other organizations in the coastal communities. So in terms of timeline, there's a few opportunities for additional comment in the future. So this isn't the end all, but as soon as I heard that there is an opportunity for comment, wanted to have you have that opportunity. We're about midway in this process on the chart in front of you, which is really like the area identification. These are the areas that are likely moving to that final stage. After this public comment's over, they will look at, do they narrow things down a little bit more based on feedback, but they wouldn't be picking different locations. So these are the areas. And then after, the next steps are really the ladder around leasing development. So leases, an auction, with notice along the way. So I think part of the comments in their letter are really trying to identify when there are future opportunities as well, and when, if others wanted to stay engaged, when those are coming. So final slide, just really in conclusion, there written public comment on the draft wind energy area, which is identified as a WIA. WIA A is, as it's in the letter, is that northern Coos Bay call area. So that is what they're looking for, public comment that's due today. Information received would make considerations of the final areas. And then, as I said, just a few other opportunities around an environmental assessment to move forward with lease information, sale notice, and so forth. So really, that's what I have in terms of slides and information. And so just in closing, you do have a letter that I drafted mainly because we're at that time frame. So it's an option if there's interest in editing it or adding to it. I'm certainly happy to help and be available. But I think it's been nice having those conversations in the last couple days with our coastal communities and Traveling County, Port of Siuslaw, Confederated Tribes, Traveling County, the Florence Chamber, City of Florence, Oregon Coast Visitors Association, and just a desire to keep in the loop and stay informed. And so it was a little bit of a surprise and a learning curve for me, so I just wanted to take time to provide you some information related to some of the public comments you have been hearing and give you an opportunity if you desired to submit those today. And I'm happy to turn it over if there's any questions.
Thank you for the presentation today, and thank you for all the work that went into what's before us in written form. And anyone watching online can click on View Item and get the entire text of the letter that is before us. And the upshot is that, thank you for allowing the opportunity to comment. In conclusion, we do not have enough information to support draft WIA A, etc. And that's the letter that we're considering today. We don't have an order before us. You're just looking for a majority head nod consent to move forward with, yep, that would be me signing the letter, wouldn't it? So then I'll look around. Any comments or questions? I'm going to suggest that my personal opinion is that well, I'll wait for other people's opinion. So, Commissioner Seneca.
Yes, well, I support the letter, but I would just like to thank you, Chief of Staff. I know you probably had to really scramble to get this put together, and I'm sure it took a chunk of your weekend, even though I don't think you'd tell us. The fact that you heard about it Friday and we've been hearing about it tells me there's a little lack of public input and public outreach. So I know I reached out to the mayor of Florence and the Port of Sioux Slaw and stuff myself, and they don't have a lot of facts about it. They've hearsay or rumor mill, and for someone that's going to be looking at these, that's not sufficient for me. So thank you. I appreciate the letter.
And so I take that as a straw poll head nod of one. So further comments? I have Commissioner Buck followed by Commissioner Lovell.
Thank you, Chair. The fact that this came on our agenda yesterday afternoon, I've been at the Oregon Wildfire Summit and we've never had a presentation about what this is about from any of the experts or applicants or really any real information presented about this, and a severe lack of time to understand the context and how it applies to us. I cannot support this letter. I find it problematic that it's a very dense letter. And so I find it problematic that this type of information is coming to us in the last 24 hours without really any context, any presentation to us. None of the commissioners actually asked for this letter that I'm aware of. I would have preferred that we did a due diligence process and went through those steps to fully comprehend what's actually being assessed here, gone through what alternatives are available, heard from actual constituents. I mean, this is just not the normal process for putting something on our agenda. And I find that very problematic. This is really touches on a lot of policy, and I don't know how much this went through our policy team. I don't know if it went through county council review. You know, if the board majority would like to send this letter, I would say feel free to send your own individual letters or put them in your name only, because at this point, I'm not ready to fully flesh this out in the last 24 hours, and I would, at this point, prefer my name not to be on the letterhead until we've actually gone through the full process of reviewing the information. And I've had enough time to really get into the meat and the heart of the matter, especially since there are additional public comment period times in your timeline ahead of us. I feel like we've jumped the gun. Thank you, Chair.
Thank you, Commissioner. Commissioner Lovell.
Thank you, Chair. I hear your comments, Commissioner Buck. I was the one that requested this letter. For the last 4 weeks or so, I believe, in my email pile, I've been getting some information about this from the Coos County folks, even in fact as early as I would say we talked about it in County College somewhere around March, June. So it's been on the radar. Unfortunately, that's the whole problem with what this letter encapsulates, is that we haven't had a lot of information on it. It's been a lot of rumor, a lot of hearsay, but the topic and subject matter have been on the table for quite some time. So I appreciate the hard work, and I know this is one of those things where I have to back up when I say government moves at the speed of a glacier. You move pretty quick. I'm totally impressed, and I think this is the right thing to send. I don't think it sends an absolute message that we're not interested, don't want to talk to you, go home, but it balances the fact that, hey, we've been hearing a lot of information that we're not clear about, and we want to have some more clear information, and we can't support this going forward without it. So I think it supports really what we're about and what our policies are about, is to make the information known and make it known to the public and sift it out. So I'm in support of this letter. And the topic, like I said before, has been around for a number of weeks, and I think we need to respond accordingly and get into the circle of information. So thanks again, Judy, for all your hard work.
Thank you, Commissioner. Vice Chair Trieger.
Thank you, Chair. I share Commissioner Buck's concerns. For me, this is absolutely a process issue. We have a process. If there is something a commissioner wants to have go out on behalf of the entire board on letterhead that lists every board member, and that is to get head nods and make an assignment and have the time for a presentation to vet. And that didn't happen. So if there's a, so that is my concern. This is in no way a commentary on the work of you, Ms. Williams, but it is out of our ordinary process. This is a complex, multi-jurisdictional project, and we haven't consulted with or had communication with our federal delegation, and this is federal issues, as Commissioner Buck mentioned, highly complex policy concepts being discussed. And to risk sending a letter that essentially says no comment, not sending the, I guess my question for staff is, what does no letter do that sending this letter does achieve for us?
Chair, Commissioner, it's a good question. I think what they're looking for in terms of comment really is some of that detail around specific impacts to marine life, environmental impacts. So while we don't have that time to identify and have that at our level, I think in hearing the conversations with our partners and several others, organizations in Florence, and feeling like the support for some of the frustrations that are voiced with the tribal government, just as an option for commenting on behalf of supporting others, that's really where I was coming from.
I guess my feeling is two parts. One is if our commissioner who represents the district where geographically this would be located wants to send a letter, that's an option. I also know we often send letters to jurisdictional partners and others outside of an official comment period if we have something we want to communicate to them. So at this time, I'm not in support of us rushing through using out of order and, in my opinion, poor process to meet an external deadline that either we didn't know about for whatever reason or they didn't do their good work in giving us enough time. That could become part of a future letter that we write. We don't have to meet their deadline to communicate our position on something, but I do not have enough of a position, an informed position, and haven't had conversation with my elected peers that would be similarly impacted or might take a position or understand something about this that I don't. We just had an agenda item where we talked about how seriously we all take our jobs. I take my job seriously, and I cannot, in good conscience, agree to submit this letter because of the process that it came to us through.
Thank you, Vice Chair. A couple of questions. Commissioner Buck has stated that that she would not want a letter sent with her name on the letterhead. What's our historical standing on that. If a commissioner or two commissioners say no to something that the board majority says yes to, can a commissioner say, well, you're doing that, in effect, have a say and just don't put my name on this, but send it on behalf of the commissioners who said yes? Or can a majority say, no, we'll put everybody's name on this?
Chair, I would say I think there's a nuance there. If the board adopts a policy or position on an issue and there's a disagreement on the board, but the majority of the board supports that position, that's the position of the board, despite the opposition of one or two commissioners. So that's just a general rule as it relates to policies that the board adopts. When you're sending a letter, this is where the nuance is, I think, is, in this case, an option would be for, I think you stated that, and we talked about this letter coming from the chair of the board on behalf of the board. So we do have letters that will come with signatures from all 5 commissioners. This is one that I think would be difficult to do that because it sounds like there's a concern, at least by 1 or 2 commissioners, to signing on to that. So, I would see the solution there as a letter from the chair of the board on behalf of the board, because it is presuming that the majority of the board supported this. Now, you're not really taking a position. You're asking, I think, expressing for desire for more time and opportunity to comment. But not all 5 commissioners agree with that action of actually sending the letter, if that is the case. Does that make sense?
It makes good sense to me, yeah. Thank you, Steve.
I don't think it's fair to you can't ask all 5 commissioners to sign on to that letter, but if the board does decide to move forward with some kind of letter, that is the action that we will take, because that's the majority of the board's position.
And the letter that we're looking at does have a letterhead including all 5 commissioners' names with my signature block at the bottom. I'm not a big fan of the bully majority, whatever the bully majority happens to be, whether it be historical or today. I believe that each commissioner, particularly on a letter of this type, really does have their personal statement that needs to be held sacrosanct. Now, on a board order, we just passed a board order 3-2. Last action was passing a board order 3-2. Everybody has got to acquiesce to that. I'll sign it today, and that board order will pass. It's not a board order. This is a letter that really is moving forward on a less of a formal path than an actual order. But that being said, both Commissioner Buck and Commissioner Trieger have stated that they would not support signing this letter with the letterhead, which included the entire board. And I'm going to live with that. I'm not going to sign a letter that has that would have the entire board's letterhead on it. We can talk subsequent to this meeting whether or not I will sign a letter on behalf of the Board of County Commissioners, whether it be a majority or not a majority, or whether it just be my signature on that letter, or whether we invite Commissioner Seneca, whose district is most directly affected, to be the signature of that letter. But at this point, Ms. Williams, thank you for the work that you put into this, and significant work on short order. I don't believe the process is out of line, quite frankly, because we get things that we have short time frames on that we have to respond to very, very quickly. But in this case, I'm not going to grant the third head nod to moving this letter forward. So, without any further discussion of this letter.
Well,
Commissioner Lovell?
Chair, if I may, about process and policy, a handful of weeks ago, we passed a board order 3-2 on hate and discrimination, and hate and discrimination proclamations. And part of the discussion was of that order was that it was in short time frame. It would be put out if hate crimes were happening on a Monday. It would be put out by Tuesday, because the board's desire was to act swiftly and affirmatively on issues of hate and bias. And one of the questions that I raised was, if we're not being able to vet the letter to have our personal okay with what sentiments were put out in that proclamation, was that part of the process? And that was not part of the process, if I remember right, we discussed. And that passed 3-2. And so, in light of what Commissioner Buck and Commissioner Vice Chair Trieger are saying about not having their names attached to something, that's something that both Commissioner Seneca and I had to live with on that proclamation motion. So as far as process, things happen fast. They've happened before. This is not out of the order. As far as your comment to the effect of the bullying of the Board of Commissioners, I can certainly relate to that and agree with that. And at the same time, I would think that if two of us commissioners were okay with this, if both our names would go on there, I would be in support of that. I think some form of action is done, but just for the public record, I want to state that this is not out of order, and there has been policies that are put in place that do not approve of every single commissioner's name on the letterhead, but those commissioners' names will be on a letterhead of some sort on other matters going forward. So I just want to put that out. Thank you, sir.
Thank you for that, Commissioner Lovell. And I'm not going to go into detail as to why I think there is a nuance of difference, as you've in part explained, Mr. McRice, between this and the internal proclamation versus a letter that's going out to a body, or regarding an order versus a head nod situation. I believe there are nuances of difference there that I'll explain more in detail at some point. But at this point in time, I will say no to signing this from the entire 5 Board of Commissioners. And Ms. Williams, if you would prepare the letter with 3 signatures, I think you may have head nods from 3 commissioners to sign as 3 separate commissioners and not as the majority of the Board of County Commissioners. Vice Chair Trieger.
Thank you, Chair. I was thinking before you said that last piece, because I didn't know that's where we were headed, and I just want to be really clear. I appreciate that you have more nuance to share, that this isn't necessarily the time or to do that, but I think that's an important discussion for us to have as a group so that we're all clear on both process and intent, and the difference between, board orders where there's a record of a vote, actions that we're taking to express the position of this organization on internal matters or community matters versus matters like this that intersect with other governments. And what I was prepared to ask for if we weren't moving forward with this letter was to ask for head nods during assignments to have staff stay on top of this, because I think part of the problem with this was we didn't have enough time. I don't know that we wouldn't have supported the position if we had had more time to really vet it and understand it. So regardless of what happens with this letter, I want to make sure that someone on staff is paying closer attention to the process so that we can monitor this initiative, because there will be many more opportunities to have an opinion about this initiative and whatever direction it might take, independent of whether this letter goes out or not. So I want to make it really clear that my position is not a position on this topic. It's a position on the process to have a letter stating a position on something this complex, this policy-laden, this much that intersects with other jurisdictions that we haven't had a thorough discussion about.
Good points, Vice Chair Trieger, and points that I very strongly agree with. And regarding this letter itself, this is a point in time on the timeline that you put up there, and I think this point in time is far to the left on that timeline, that there's plenty of information that's going to happen. And subsequent to signing a letter not supporting it this time, more information can come out, may come out as we move forward. For instance, none of the area in A is off of Coos County. It's all mostly off of Lane County. And our tribal governments, the Clusie in particular, has expressed an opposition at this point in time to moving forward. I'll tell you, that means a lot to me, that because they really are deeply vested and involved in what happens in the land and in visual context with the land. That's why I would, at this point in time, agree with the tribal governments and say we're not in support. I'm not in support at this point in time, but that could change as more information comes forward. As maybe it's going to become evident, and maybe the Clusie government will say no. After more information has come out, we do support it, or we're neutral on it, whatever it may be. It's going to be a time to change that potentially. But at this point in time, I'm okay personally signing the letter that you've produced without the complete letterhead of the board. So, is there any further discussion on that? Any further discussion? Then Ms. Jones. Ms. Williams, is that fairly clear what I have suggested? And it looks like we have, I'm not asking for agreement, but concurrence with the letter that's not going to go out with the entire Board of County Commissioners' name on it. Ms. Mokryski, anything that you'd like to add as far as is there anything that we're tripping up on here that you can point to?
Plenty. But that's a process issue, so we'll work on that going forward.
Very good. Thank you, Ms. Morkowski. Then with that, we'll close this item and move down our agenda. Next item is announcements from the Board of announcements, Ms. Morkowski.
Let's see, just appreciation again, and for the comments on the Oregon Wildfire Summit, first annual Oregon Wildfire Summit. As Commissioner Buck mentioned, we had about 200 people attend from across Oregon, from Portland, Klamath, Jackson, Lincoln, Deschutes, state agencies, federal representatives. And in addition to just the content and the information share, the community practice, the state policies, I am really excited about the extent to which Lane County's continues to gain credibility from a statewide perspective at being a thought leader, I think in large part because of our partnership with the University of Oregon and our policy lab work and our desire and ability to convene various folks across the state on these big issues. So we're going to do a lot of lessons learned from this and see how we can leverage those opportunities on other issues with those partners going forward. So thank you for the board for supporting that work. And then just a quick update on elections. We had the October 3rd Holvey recall election. Results have been certified. There were 12,084 votes against the recall and 1,349 votes for it. So just over 13,400 total votes cast in that election. And then the November 7th special election, the turnout is low so far. 7% of voters had returned their ballots by last Thursday, October 27th. Twice as many voters are using Dropbox sites. You can see the dashboard for voter returns by district, precinct, and source, and then the second public logic and accuracy test will be held on Monday, November 6th, immediately before ballots are scanned. I think that's everything I have, Chair.
Thank you, Ms. Morkowski. Any questions or comments? Then we'll move down to Commissioners' announcements. Any announcements from the Board of Commissioners? Seeing none. Then future board assignment requests. Commissioner Seneca.
Yes, I would like to look for head nods. Saturday, November 11th is Veterans Day. If we could get a proclamation to be read on November 7th, celebrating that would be great. I believe we have a couple of veterans here on this board.
I'm good with that, yeah. Okay. There are a couple of veterans, and also veterans' families are rife on this board, so very good. Then, oh yeah, good one. Thank you, Commissioner. Further requests? Then, Ms. Morkowski, on that last request that you just received that Ms. Williams walked out with, which was a letter to be signed by three, I think maybe three separate letters to be signed singly by commissioners?
I actually will have to explore that because I think there are concerns about that constituting a quorum. I think my suggestion would be, if your concern is having that there be a letter from the chair on county letterhead that just says on behalf of the Board of Commissioners.
Okay, and I will concur with that.
We can find, that probably will be the cleaner thing.
Okay, then I'll see you after this meeting, because we have probably a 5 p.m. deadline on that, I would guess. Very good. Okay, any questions, any further board assignment requests? Then we'll ask for a review of assignments. Ms. Morkowski.
So request, and I think the thing I just want to think through is because we don't do proclamations, we could do a board order or a letter of some kind. I'm trying to think, I think the sentiment of what you're asking is how can we celebrate and recognize Veterans Day? So let's take that as the assignment, and we'll get creative in figuring out how we can do that within what our processes are.
I heard a parade and flyover.
Mariachi band.
That may be tough, yes.
Make the phone calls.
I have a thought, I don't know if this is anything that even comes close to satisfying, but it just occurred to me, I think about how we do employee recognition. And I don't know if we have data about how many people at Lane County are veterans or veteran family, or just, maybe a prepared statement that gets at that, and then also a comment just more broadly, externally acknowledging the significance of the day. Maybe it's just a prepared statement, which we have in the past had prepared for the chair to read or something like that.
Well, and maybe something I could do is check with Joby Riley, who's the head of our Veterans Office in Lane County, and see if he is available to come and maybe do so we can work. If that sounds like a really meaningful thing to do, be able to talk about, yes, how many veterans we have in the community and in the organization, the services we're providing, the support, what the needs of veterans are here in Lane County. That would be a really nice thing to do if the board.
Yeah, that'd be great.
Support that. Okay. So we'll take that as the assignment to, for staff to bring forward a recognition of veterans in Lane County next Tuesday, is what I heard you say at the board meeting.
Yeah.
Yeah, so we just worked on it. We had agenda setting this morning, but we can work with Ms. Jones to see about timing of doing that and seeing if we can do that at the beginning of the board meeting on Tuesday.
Thank you. No further questions, no further assignment requests, and thank you for that review, Mr. Mokrowski. We do have a call for executive session this afternoon. So at the sound of my gavel, the Board of County Commissioners will recess, and we will reconvene in executive session at exactly 3:30 in the BCC conference room. Subsequent to that, if we do not come out for business after the executive session, then we will reconvene at, is it 9 o'clock tomorrow? 9? It is 2 p.m. tomorrow. That was a question to see who was paying attention, and I was. We'll reconvene at 2 p.m. tomorrow for a Health and Human Services discussion on the Lane County Stabilization Center. So at the sound of my gavel, we are recessed and in executive session to be returning to regular session at 2 p.m. tomorrow. So with that, the Board of County Commissioners will meet in executive session to consult with counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to ORS 192.6602H, which allows the Board of Commissioners to meet in executive session for the purposes listed. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are precluded from attending. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. Members of the news media are not allowed to tape, video record, or otherwise record an executive session. Verbatim notes are prohibited. No decision shall be made in executive session. We reserve the right to come back out into public session should the need arise.